Hey folks, welcome back to the Law and Crime Network. I'm Michel Bryant with you for the afternoon. I think it's official. I think we have a doozy for you today. And we have so much to cover. Yes, it can be a bit confusing. Here's what we believe is happening in the Nelson case there in Florida. Luckily, I have some great guests here to help sort through this mixture. Anytime the Scott Nelson case is involved, you know it's going to be a little unusual, not pro forma. We know that earlier today, Scott Nelson took the stand in the penalty phase. Who could stop him? So he had his say. There was a brief cross-examination because the direct examination was very brief. And we'll talk about that. The reason for that, we believe, was purposeful. And so now there's been some rumblings by the defendant that perhaps he's not getting efficient counsel. And if he's not getting effective, efficient counsel, then his constitutional rights are being violated. And now we're hearing some sort of attempt to clean up something he testified to earlier in the day. So, okay, with me here on the set is Norman Williams. Norman, thank you so much for joining me. And also Joseph Tully with us. I'm going to ask you both to chime in on this as best we can at this point. Certainly this hasn't been decided, whatever's going on. What's your take on this penalty phase portion, the defendant's testimony, and where we are now?
I think everybody is focusing on how the judge seemed to be handling Mr. Nelson with kid gloves. And I think he's just protecting the record. And he's just trying to make sure that this case doesn't come back on appeal. But it's not uncommon for a defendant facing what he's facing to, during the middle of the trial, claim that he's not being represented effectively. That's not an unusual thing.
We heard Joseph earlier today. We heard some legal arguments, really, from the defendant, and they weren't bad. You know, they weren't horrible. They had to do with whether or not he took the stand, and if so, he was cross-examined and basically exposed as a, quote, liar. Could he bring on folks that would rehabilitate his original testimony, saying, well, no, these things actually happened. He was not a liar. There was a huge back and forth on that before the defendant ultimately said, no, I don't want to delay justice. I think is what he said. What's your take on that, both as it relates to the process and this defendant?
Boy, this trial has been a lot of twists and turns. So I think he's very headstrong. He wants to be in charge of things. I think that's probably some of what's going on right now. And again, I agree that it's not unusual for a defendant to question their attorney in the middle of trial. And in terms of what's in his mind, one can only speculate.
This jury has got to be just pulling their hair out. It's just delay after delay. And they briefly came back when the defendant took the stand, ready to go. He's standing at attention. Remember, he's shackled, so they don't want him walking up there in front of the jury, clanking his way up to the stand. So he's standing there, he sits, and immediately defense counsel says, can we have a sidebar? I mean, how important is it, Norman, to keep the jury kind of engaged and, I don't know, not mad at you?
No, it's very important. And a lot of times delay gets blamed on the defense when it just shouldn't. And judges usually make extra efforts to remind the jury that there are a lot of things that can delay a proceeding, and you can't blame either side or even the court for those delays. It's just the cost of doing business. So,
Joseph, let's take a step back. Of all the, the craziness that's taking place procedurally with this defendant in his own, charm, what do you think the jury is thinking at this point? Are they just ready to get it over with? Are they still engaged? What's their mindset?
It's really hard to speculate on a jury. I think most trial attorneys who have, years of experience and lots of experience will tell you, don't try to speculate. You might try to feel them out, as you walk by them or something, you could kind of feel their emotions, if that makes sense. But as a trial attorney, you have to do what you have to do. So you don't shortchange the record, absolutely, unless you have to. You keep going, you do what you have to do, you present the jury your case that you want to present, and if they're mad at you for doing so, you hope to apologize during closing or hope that they can listen to the judge's reminders that not to blame you for the delay, but a defense attorney has to do what they have to do. You have to make a complete record.
Yeah, and I think, with any luck, this jury is, well, they're certainly going to be entertained by the defendant, but hopefully they're taking all of these delays in stride. And for anybody who's received a jury verdict or have talked to jury members after the fact, you're constantly surprised at what was getting their attention, what they were focused on, and what ultimately helped them get to their decision. So we're going to get back into that Florida courtroom for more of the Scott Nelson trial. We'll also keep you posted on Spacey up in Manhattan, in Nantucket, and, of course, what's going on right here in the New York area with Mr. Epstein. So stay right where you are. This is the Law&Crime Network.